We have, when it comes to rape, when you look at what the penal code says, the penal code is the criminal law that is operational in the northern part of Nigeria. Then you also look at the criminal code, which is operational in the southern part of Nigeria. Then you look at case laws. Case laws now will be judgments from courts, we say more especially from the Court of Appeal. Now, cumulatively, these three sources of laws, when it comes to rape, defines rape to be the sexual intercourse, penetration of the male organ into the female reproductive organ without consent of the female. And even where there is consent, the consent was gotten by force or deceit. Then the parties involved here, that's the rapist and the victim, not being married, that's not being husbands and wives as it is. Now that is what makes up rape. Now this was up until 2015. Since 2015, this definition has changed. Why? Because we have the law, a federal legislation we call the Violence Against Persons Prohibition Act of 2015. That particular piece of legislation makes it that rape is now the penetration of any opening in any person's body part with anything whatsoever. So if you look at the constant word there is any. Unlike what we had under the criminal code and the penal code and the judgments of the Supreme Court and courts in Nigeria, now, under the Violence Against Persons Act of 2015, it is now any. That any there, the first any you will find out is any person. So if a husband rapes a wife, at that point, it becomes rape, as opposed to what the criminal code and the penal code limited it to be earlier before 2015. Now, before 2015, for you to prove rape, the definition-wise, you need just the slightest penetration to prove it. But the Violence Against Persons Prohibition Act has made it that even any penetration into the mouth or anus or any opening, if by any chance you can even put the nose and the ears, anything whatsoever like that. Now, other argument, we have cases where maybe by the definition, people, issues of maybe inserting finger or inserting object were held not to be rape. But by the Violence Against Persons Act, such things are now rape. The punishment under the criminal code is life imprisonment, with or without fine. You now go to the penal code. The penal code also said life imprisonment or lesser time. Now that's why I have problem with that law. Because in sentencing, a judge has found Mr. A guilty of rape. He now wants to convict him, wants to now sentence him, say, to XYZ period of imprisonment. The judge must be mindful of the maximum time period for that offense. And when you have life imprisonment, it means that that is the highest you can have. Now that means you see cases where maybe a judge may put the person away for, say, 7 years, not life imprisonment. Now, to change that scenario, where judges had a lot of discretion to give anything not above life imprisonment, that's where we have the Violence Against Persons Prohibition Act. By that particular act, the maximum is life imprisonment and the minimum is 12 years. So whatever the judge does, he cannot give you for rape less than 12 years. That's awesome. Because my argument has been, if you keep making laws and you set only the maximum without setting a minimum, that means that the court has a discretion to go even to give a day imprisonment. You can't question him for that. But when you set a minimum of 12 years, that means for any case of rape, the least the person can get under that Violence Against Persons Act is that 12 years in prison, and that is very commendable.